My legal costs are so extortionate, they're up to 18,000, that they're no longer affordable.
That's a lot of money to have spent and only be at the first hearing.
There's a lot of financial control, emotional control. I have no funds, I have no access to funds. What is my next step?
You need to give the Civil Legal Advice Line a call. They will assess you as to your eligibility for legal aid.
The DD1 form wasn't correct. No matter what I said, you just wouldn't accept it.
We've got to look at the order that the court has made and compare it to the order that you guys think should have been made. We're not going to spend £10,000 if we're arguing over £5,000. Do you know what I mean? Hi everyone and welcome back to the Legal Queen live show. My name is Tracy Maloney, aka the Legal Queen on social media. I am also a practicing family law solicitor and have been now for over 20 years. During that time, I've answered lots and lots of questions around divorce and finances and of course child custody. If you have a question that you think I could help you with, then please join me on my Discord channel. Come into the Legal Queen Lounge, pop your hand up and I'll get to you as soon as I can. Now on with the show.
Hi, Tracy. I'm just wondering, I'm at the stage of having come out of FDA and needing to go to FDR, but my legal costs are so extortionate, they're up to 18,000, that they're no longer affordable. Would it be awful to go as a litigant in person from this stage on? Because he did agree. I wrote up a settlement offer which cost me £1,800 following the FDA, which couldn't be converted because he keeps missing deadlines and not doing things. And he said he would agree to it, but they've missed the deadline on that and they're not responding to. The court said that they had 6 weeks to respond to the questionnaire. Again, they're not responding. And it's just running up costs. And so I've asked my solicitor not to chase because it's just wasting my resources, basically. What can I do?
Well, you can represent yourself, absolutely. You know, the court isn't going to pass judgment on you because you had solicitors and now you don't. I'm always saddened when I hear of such massive costs and you've only had one hearing. You know, the FDA is the first directions appointment. That's a lot of money to have spent and only be at the first hearing. But you are where you are. So to answer your first question, yes, you can represent yourself. The other thing I would add to that is you may be, now I don't know what's happening in your financial matter, but you may be able to apply for a litigation loan. In other words, if you're getting equity from a property or a lump sum at the end of all this, you could then pay it back. If you felt that actually by not having legal representation is going to jeopardise your case slightly. But generally it won't. You know your case. I'm sure that having spent £18,000 already, you know what you're legally entitled to. And if the majority of these costs have been just...
I actually don't, because I feel like the other side have been gamesmanship the whole way. Like their For Me is complete nonsense. They haven't put certain things in, but every time they miss it, we did a penal notice and a cost order and the judge said no. And again, they're just missing each deadline, but there doesn't seem to be any real consequences. And I don't really have £3,000 for a barrister to go to FDR now. I've put the settlement in, which I thought was really generous and would negate them having to do the questionnaire, which would have been costly for them. But I'm also, running out of resources and time, so I might end up losing being able to stay in the home.
Sorry, so you
and every time it just runs up more costs.
So you jumped in there, Kat, to say that you don't know what you're legally entitled to, but then your example was that he's stalling. So I'm a bit confused. Do you know what you can obtain? Have you been given that advice?
Sort of, but because his Form E is so hectic and there are assets that are in his name that he's trying to argue aren't in his name, it depends what the judge would consider, really.
But you've made an offer. You've made an offer.
I've made an offer.
Yeah.
I've based that off of my mortgage raising capacity and the difference between the mortgage.
So if it comes to you not being able to afford legal representation, which was your first question to me, and you want to proceed on your own, you can do that sticking to your offer. You've made your offer. So had he accepted that offer, then we draw up a consent order and everybody would go home. So, at the very least, at least you have a strategy there. You know what you're going to court for to ask for yourself. Do you know what I mean?
Yeah. No, that makes perfect sense. Thank you.
All right. Pleasure.
We went to the court here, and the judge asked for the financial order to have a 20-minute hearing.
Yes.
Which there was some speculation around what that was for, but so we went in, and he basically said that the joint letter that we'd both sent in that was signed by both of our solicitors and agreed. We spent pretty much a year going back and forth over this joint letter. Didn't make any sense to him whatsoever. And he's just discarding that and went back to the original D81 form, which we'd kind of already highlighted had some mistakes on and was basically incorrect, and showed a split which would have been more like 67% towards me, and very, very unfair. And no matter what I said to him to say that these numbers aren't correct, he just wouldn't accept it, and said, basically, for the amount of that was in the pension wasn't all that much. It would cost too much money to sort that out from a pension share, and that I kind of need to give him more cash. Was ultimately what we came out of. So I kind of came out of that a little bit despondent, really, because I don't know what to do next, because the D81 form wasn't correct. He's going off incorrect numbers, and he wasn't willing to entertain anything else.
Yeah.
And I don't really know where to go now. He mentioned about appeals and things like that, but
yeah.
It just all sounds very expensive and complicated. And
this order, David, just remind me, it was by consent, wasn't it? You hadn't filed a Form A. Yeah. I think, and is your ex-wife in agreement with the order that's made or not?
I'm sure she'd like more money if possible.
Okay.
but by and large, she's we've gone through this a million times, and she's in agreement. But I'm sure if there was some more money being put forward, she wouldn't say no.
So you both feel that the order that was made wasn't appropriate, essentially.
Well, one thing I haven't done is sat down after that court hearing and discussed the specifics around what was incorrect in the D81. What I was initially said to her after the thing was, we need to sit down and make a new D81 because this one's not correct, and we haven't done that yet. So she was open to having that conversation.
Okay. I mean, I'm not so sure. I'm not so sure that you need to do the D81, because the D81 is for the judge, and actually the judge has stepped out now because he's given you a final order, whether you guys are happy with it or not. But to answer your question, your first step is going to be you particularly to speak to your solicitor and take advice on that. Is this worth going back to court to say we need this relooked at by a different judge? That would require your solicitor to do a D11. D11 simply asking that the matter be listed for a further mention because we feel that the order made was unfair and unreasonable. But the reason that I think that you've got to take some advice is because we've got to look at the order that the court has made and compare it to the order that you guys think should have been made. And is there much material difference there? Is it proportionate to potentially the legal costs that you may incur taking it back? Or do you just draw a line under it and move on? Because the thing that I would say, David, is that nobody wins when we go to court. We are asking the court to make an order. The court's going to make an order that it feels appropriate. Now, the court gets it wrong from time to time. Of course they do. And that's why we have to go back. You don't necessarily need to appeal this one. You might just need it re-looking at with the correct information. But for
that's what I feel.
Yeah, for you, I think you need to go back to your solicitor. There is no point you and your ex sitting down doing a D81 and sending it back into the court, because the court's got no power to look at that now. The matter's finished, it's closed, there's no application before it. So your solicitor's going to have to make a D11 application, would be my suggestion.
So I did contact my solicitor, and they said until they actually issue the paperwork from the court, that it was kind of pointless having the conversation because we don't know what it says.
Yeah, fine.
Would that actually have specific numbers in it around what I should be Is that what we would expect back?
No.
Or because
Well,
what
it,
he's
it depends. It
yeah.
depends what the order says. I mean, he may include specific numbers in it, but when the order comes back, you can attach to it the D81 that he was relying upon, he being the judge, so that if there are no numbers in it, at least you can say to your solicitor, well, look, this is the D81 that he was relying on, and this is the order that he made out of that. That's where I would start if I was looking at it, yeah.
Yeah, I mean, my instinct was to just try and sort this out with some cash, but when I've sat and looked at it, it's like that's actually more 55% in my favour than 60%, 67% in the original form. And I've got the kids full time, so it kind of feels that is fair.
Okay.
So it's my instinct is to kind of argue it out a bit more, but if it's going to cost tens of thousands to go back to court, I'd rather not do that.
And this is where your solicitor will be able to guide you, because at all times we have to make sure that costs are proportionate. We're not going to spend £10,000 if we're arguing over £5,000. Do you know what I mean? And sometimes it's not just about the cost. You've already told me today, and I know previously, you guys have been doing this for a while. There's an emotional strain there too. Sometimes it's better just to draw a line under it, walk away and think, okay, fine, let's just move forward.
Okay.
All right.
Thank you, Tracy.
Lovely.
I'll try and do that.
No problem. Thanks, David.
Excellent.
Take care. Bye.
I've been married for about 20 years, 22 years together with my soon-to-be ex. I've applied for divorce. During the marriage, there was a lot of financial control, emotional control, narcissistic behavior and such. I left the marital home in October of last year with my daughter because of some very concerning behavior he had towards her. We've been in a shelter, and I think he had put forward child arrangements orders. So that's going through the court. The question I have is with divorce. I have applied for divorce and I've gotten the conditional nisi, is it?
Conditional order.
Yes, the conditional order, sorry. And he had agreed to do mediation. He's uploaded some documents, but not all of them. So I think the mediation might fall through because he's not being very forthcoming with information. My question is, what is my next step? Do I seek legal advice? Would I be able to get that on legal aid? Because I have no funds. I have no access to funds. I'm going to begin working soon, hopefully. But everything is in his name, and he has like 2 properties and loads of pensions and savings and things like that.
Okay, so the divorce is fine. That's looked after. Are you going to mediation because you're trying to sort out the finances first of all? Let me just double check.
Yes.
Okay.
But he's not forthcoming with information. He's just giving part information and not all of it.
So if he's not in agreement to mediation's voluntary, so we can't force somebody to go to mediation. So if they don't want to do it, that's fine. The mediator will give you the MIAMS form, and that's the form that you then attach to the Form A. And it's the Form A that triggers a financial application. So that's that. Your question then was, are you entitled to legal aid? I don't know the answer to that, but you need to give the Civil Legal Advice line a call. Their number, have you got a pen handy?
Yes, I can do that. 1 second.
So their number is 0345 345 4345. Okay, and if you give them a call, they will assess you. It generally takes between 15 to 20 minutes, but they will assess you as to your eligibility for legal aid. And then if you are eligible, they will point you in the right direction of a legal aid solicitor. But if you're not eligible, then you're asking the mediator for the MIAMS form and you're attaching it to a Form A, which you'll fill out. And it's really straightforward, the Form A. You'll be able to do that and you'll send that into court. Nothing will then happen for about 3 months. So at least you can get it started, just because it takes about 3 months for the court to give us a hearing date.
Okay. Would I be able to represent myself in court, or should it be preferred to have a lawyer?
No, you can represent yourself. I mean, lots of people do.
Will courts factor in CMS payments if I make a Schedule 1 claim for nursery fees? CMS payments aren't enough and father won't pay extra to cover nursery fees to spite me and because our child doesn't live with him. But put in his position statement that he's not happy that she's not in education. When asked by the judge if he can afford the nursery, he said yes.
So ultimately, it's going to depend. It's not an isolated question. Yes, of course, there's any income that's coming in is going to be taken into account, and that's going to include the CMS payment. The question here is around before the parties separated, were both parents adamant that the child would attend this particular nursery? Is there a cheaper alternative? If the answer to that is no, and the child has to go to this nursery, then, you know, the application is, well, can dad help me out with 50%? The difficulty I have with this question is the court won't make an order as to debt. So if dad proves that he cannot afford to give mum any more money, then unfortunately the court will say, look, I can't then make an order. Because if we make an order, or the court makes an order that then forces somebody into debt, it's appealable. So this person, if not already, has to get some advice. And it won't take long. You know, this wouldn't take an hour of advice, sort of 30 minutes. But because we can't just look at that one isolated segment of the case. Will the court take into CMS on the back of my application for Schedule 1? Yes, but there are so many other elements to it here.
My children have equal share care with both their mum and me, and their mum has taken us to court as she doesn't agree, raising many false allegations against me. We have had the Section 7 report, and Cafcass recommended to keep it the same.
Yeah.
But now, after the second hearing, we now have a final hearing because she argued it so much that we didn't agree. So basically, her representative will be questioned by Cafcass. My question is, are the court likely to overturn the recommendations of Cafcass?
It's unlikely. Usually the courts are heavily guided by Cafcass and in some situations social services because they are that independent third opinion and they are there to represent the best interests of the child, where mum and dad have like a polarised view. So if dad is in agreement with the Section 7 and the recommendations made, and obviously Cafcass are because they've made the recommendations, then I feel that mum has got the uphill battle there. Mum has to show the court categorically that what Cafcass is saying actually is not in the best interests of the child. And that's going to be difficult. So I would suggest that there's less of a worry for dad in this example and more of a battle for mum, who disagrees with it.
My soon-to-be ex-wife has never worked during our marriage of 17 years. She has newly qualified after 3 years of training. The per annum salary for her qualification is probably starting at around 35k. But she is finding it hard to find an open position. My question is regarding divorce and financial order. If your ex-partner is unemployed but able to work, how would the courts allocate the equity from a house that is 95% mortgage free? How much months would they allocate for this, and how long? Is there any guidance that the courts follow?
No, I mean, I say this over and over. Family law is very bespoke. So you're not going to be able to Google or even ask me a question and get a direct specific answer to your query. You have to get the advice. So we have a property that's 95% mortgage free. And the question is, how much is my ex going to get of that house? I would have absolutely no idea because I don't know how long the marriage is. And please don't answer these questions, Captain, if you have these answers. I don't know how long the marriage is. I don't know how many children we have, if we have children. I don't know what the party's mortgage raising capacity is. And when we're doing a consultation with a client, these are all the questions that we need to be asking. Because if she has no raising capacity now, mortgage raising capacity, because she's not working, it might be that she needs a larger lump sum to be able to put down a bigger deposit or even buy something outright. But then you see that could lead itself to an argument that, yes, but she will have mortgage raising capacity in 6 months' time. And the only way that I would be able to give advice on that element is to know the history to this marriage. You know, was the intention that she was always going to get these qualifications and then return to work full-time or part-time or whatever it might be? So very, very difficult for me to answer that one.
Contact with son and his father was suspended by legal advisor due to him not following the C100 court order.
Yes.
I'm in the process of doing an urgent application to the court to get the order changed.
Yeah.
In the meantime, can my son's father turn up at his school and take him, even though he has had a letter stating that contact is not to go ahead until we've been to court?
So letters from solicitors aren't legally binding, which means that the school can ignore that. If father has parental responsibility, then absolutely he can go to school and collect the child. The schools have to be guided by orders because it's the orders from the court that are legally binding. Whilst the solicitor has written out to him to say, look, until such time as we get to court, please don't have contact with the child. It's not legally binding. Dad can ignore that, and so can the school. In fact, the school would have to ignore that. They will only be guided by an order.
Well, I can say as a chair of governors, Tracy, schools don't get involved in parental disputes.
Yeah.
Otherwise, we'd be inundated with parental
Yeah.
disputes. Unless there's a court order that's signed and sealed by the court, we won't do anything if you've both got PR.
Yeah. So what Captain is saying, for those of you that can't hear on TikTok live, Captain is actually a school governor, and he absolutely agrees with what I've just said. Schools will not get involved in parental disputes. They will only be guided and bound by any court orders that are made, which says specifically the parents can't pick the children up from the school or what have you. I mean, and clearly there's a reason why schools don't get involved with the parental disputes, because they've got work to do, they've got jobs to do, and sadly there's lots of parents in dispute.
Yeah, because we'd be dealing with something every day, Tracy.
Yeah, exactly.
Because parents fall out every day.
Yeah, yeah. And the thing is, and I say this all the time, Captain, you'll agree with me, it comes down to co-parenting. A lot of the times these aren't legal issues. They're just not legal issues, just co-parenting. We fall out with each other as adults, and then we have an inability, and I get it, I absolutely get it, but we have an inability to then be able to co-parent effectively.
Do you ever get to a stage, Tracy, at that, after being in family law for 20 years,
Yeah.
that you're still surprised by something that comes up?
Absolutely, absolutely. I think I've always been fascinated by people, which is why I have such a love for family law. And yeah, I never stop being surprised. You know what people will do, and of course, as I get older, I'm seeing the problems change. You know, the problems that we had in couples when I first started practice 25 years ago are very different to the problems we're having now, because obviously of the internet and social media and all the rest of it. And it keeps me inspired and interested. So yeah, I genuinely love it.